Hey everyone, in this video I am going to talk about writ petitions. Article 32 and 226 of the Constitution of India enumerates the provisions relating to the same. Article 32 enumerates that writ petition can be filed before the Supreme Court, and Article 226 states about writ petition before the High Court. And these articles are very much important from your exam perspective, and if you practice in the court, then it is of vital importance. According to Baba Sahib Ambedkar, Article 32 is the heart and soul of the Constitution of India. Article 32 of the Constitution of India actually states about a writ petition before the Supreme Court. Article 32 comprises of 4 clauses. Clause 2 enumerates the provisions relating to writ petitions. It actually states about classification of writs. There are mainly 5 kinds of writ. Number 1, Hebes Corpus, Mandamus, Prohibition, Certiorari and Quo-Warranto. So, these are the 5 kinds of writs that have been recognized by the Constitution of India. And in this video, I will tell you all the key points of these writs. Because if you remember the key points, it will help you to understand the law and it will help you to remember well. Now, let's start with Hebes Corpus. Hebes Corpus is one of the extraordinary remedy that has been provided by the Constitution of India, where a person has been detained in the custody of another and that detention has been done by any authority, and such detention is absolutely illegal or wrongful, then you can apply before the court the writ of Hebes Corpus. Now, say for example, suppose you have been detained by the police officer wrongfully. Then you can apply before the High Court, or your family members can apply before the High Court writ of Hebes Corpus, and then High Court will issue summon to the police officer in order to justify the grounds of arrest or detention. Then the High Court will direct such police officer to justify the grounds of detention. And if the police officer is unable to justify the grounds, then such police officer will be directed by the High Court to release the person who has been detained. So, in order to apply the writ of Hebes Corpus, the prime or paramount consideration is that the detention should be by any authority. Suppose your relative or your friend detained you wrongfully. Can you apply writ of Hebes Corpus? The answer is no, because your friend or relative has no authority to detain you. When the detention is by the authority and such detention is wrongful, then you can apply before the High Court the writ of Hebes Corpus. Now let's move ahead to the another writ, that is writ of Mandamus. This writ can be issued by the Superior Court against Inferior Court, and this writ can also be issued to any tribunal, board or any administrative authority where there is non-performance of their duty on their part. The one of the most important aspect regarding Mandamus is that it cannot be issued against any private person. So therefore it is only the state or a person who is holding any public office at that point of time it can be issued. But where a person who is not holding any kind of public office, it cannot be issued. Say for an example that where the judge of the court who is duty bound to follow the principles of natural justice, if is there any failure on his part to follow the principles of natural justice, then the writ of Mandamus can be issued against him by the Superior Court. Now let's come to another writ, that is writ of Certiorari. Writ of Certiorari is different from all the other kinds of writs because it can be issued only where there is a mistake or error committed by the Inferior Court. Then Superior Court can issue such writ for the purpose of correcting that error. Let's have an example. Where the High Court has passed an order, is the District Court has the power to review such order? The answer is no, because High Court is the superior than the District Court. So that's why if is there any kind of mistake or error committed by the Inferior Court, then a Superior Court can rectify such order by the application of writ of Certiorari. Let's have another example. Suppose a court which have no jurisdiction to try a particular matter, but such court tries the case and passes judgment. then such judgment will be quashed by the application of writ of certiorari. Now let's come to another writ, that is writ of prohibition. Writ of prohibition can be issued where the inferior court is overstepping its jurisdiction. That means inferior court is doing something which the inferior court is not supposed to do. So writ of prohibition is something which is always issued before the inferior court or any tribunal passes its final order. So writ of prohibition is something which is actually to prevent the inferior court to do certain act which is not for them to do. Now let's come to difference between writ of certiorari and writ of prohibition. Writ of prohibition is something which can be issued before the inferior court pass an order, but in case of writ of certiorari it can be issued after the inferior court passes its judgment. Now let's come to another writ, that is Quo-Warranto. The term Quo-Warranto means by which authority. The writ of Quo-Warranto can be issued in a situation where a public office has been wrongfully assumed by the private individual. In order to apply the writ of Quo-Warranto, such public office must be constituted under the provision of Constitution or under any other statute. And the writ of Quo-Warranto cannot be issued against any other person who is not holding any public office. So, where the person who is holding a public office, against such person the writ of Quo-Warranto can be issued. The power that has been given to the court is absolutely discretionary in nature. So therefore nobody can demand that the court is bound to extend its power under this writ. So these are the 5 kinds of writs, and these are the key points that you have to remember, because these are the sole structure of each and every writs. I hope this video will help you a lot to remember the concept, and this will help you to remember the law in a better way. So that's all in this video. I will see you on the other side. So till then, stay happy, stay blessed, and keep learning. Thank you so much.